Manever I say ma PENDREAM TV. PENDREAM TV there, osia dem yopo.
You are most welcome to PENDREAM TV, the only channel that brings you the best and latest updates in politics. If you are new here, please don't forget to subscribe to the channel, hit the notification bell for more updates, like and also share to other members to watch as well. You can equally leave a comment after watching or send us a voice note on our WhatsApp number, which is 0277128777. Thank you. I want you to join me listening to what Professor Gyampo has to say about the Supreme Court ruling. Thank you.
Living in a country where the parliament is not sitting, what is going on?
I'm not sure that this suit is to enable parliament sit, is to declare.
Very well.
Yes,
I take it that's really in your
so if I would.
It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
Lord, we are extremely grateful.
So, Mr.
Lord, we are grateful.
So, Mr. Sorry, will you be filing anything, or should we hear without you?
Oh no, I don't have instructions on that matter, but especially so that if my lady looks at the affidavit that I filed, I said the order was served on the Speaker on Monday, so he has 7 days. I will speak with him to draw his attention to the courts.
Exceptional circumstances that would flow from the effect of the ruling of the Speaker of Parliament declaring the 4 seats vacant and a determination not to allow the MPs to remain in Parliament. What are some of the effects that weighed on our minds as exceptional circumstances that were alluded to in the ruling? The 4 constituencies of Amenfi Central, Fomena, Aguna West and Suhum in the Western region, Ashanti region, Central region, and Eastern regions of Parliament are made up of hundreds of thousands of Ghanaians who had queued to elect these members of Parliament to represent their interests in Parliament as their voices. By declaring that their duly elected representatives in Parliament had vacated their seats for acts that were interpreted within the light of Article 97(1)(g) by the Speaker. The Speaker was actually enforcing this interpretation of Article 97(1)(g) against those hundreds of thousands of Ghanaians, and not just the 4 people that sit in Parliament. We have considered the application and find that the grounds supporting the application have no merit because of the very explicit and clear directions of the 1992 Constitution, specifically Article 2, Article 130, and Article 296, and established decisions of the Supreme Court from decades of the country's constitutional history. Grant of orders beyond 10 days. The Speaker's lawyer urges that because of Order 25 Rule 18 of the High Court Civil Procedure Rules 2004, CI 47, that enjoins high courts to grant injunctions and other preservation orders for 10 days in the first instance if heard ex parte, and without notice to one party summoned before the court. The Supreme Court was also enjoined to grant the ex parte order for 10 days as a matter of rules and practice.
Well, as was expected, good morning from our studios here at Adesawe in Accra. The Chief Justice, and together with her panel, had the Speaker's application. And what we have been playing to you is a ruling of that 5-member panel. Welcome to the Key Point here on TV3. On this program, we discuss the most topical issues of the week with our well-informed, passionate, committed Ghanaian citizens who want the development of this country in many ways. We're live on 3FM 92.7, also on DSTV channel 279, all across the world on 3news.com. We're live on X as well. As you heard, the Supreme Court dismissed that application by the Speaker of Parliament, asking the court to vacate its ruling that
what we will do to make sure they are where they are, which is with us, will continue.
No, but what is their status now? Are they still
They
MPP?
are members of the party.
They are MPP MPs.
Yes.
But does that violates your party's own constitution?
Yeah, but then you see, I have said that.
Taking some of them from your WhatsApp.
No, but no.
But that doesn't mean anything.
No, but if
their party
they are
has
still MPP MPs.
Their party has to issue a letter, and I refuse to go beyond this because that determines the matter before the Supreme Court.
Okay, now I'll bring in Prof. Down, but you see, if you still maintain the point that they are still NPP MPs, here's what your constitution says. A member may be expelled from the party on grounds of misconduct in accordance with provisions of this constitution, and upon such expulsion shall cease to be a member. Let's go to the next slide. It says, no member shall be expelled unless such expulsion is affected in accordance with the provisions of Article 4. The next one, forfeiture of membership. A member of the party who stands as an independent candidate against the officially elected member of the party, or who joins or declares his or her support for another political party for an independent candidate, when the party has sponsored a candidate in a general or by-election, automatically forfeit his or her membership of the party. So the party doesn't even have to write.
No. You just
read
speak
now.
The first line you said, shall be there has to be an expulsion, isn't it? Has there been an expulsion?
Let's go to point 9. Point 9 is the forfeiture of membership.
No. You premised it on expulsion. Has the party expelled them?
That's a different.
It's not, but you premise it on that.
So forfeiture of membership. That's what is on the screen now. You can see it.
Yeah, but you premise it on expulsion by the party.
That's a different provision.
How is it not linked to that?
Gentlemen, wait. A member of the party who stands as an independent candidate against the officially elected member of the party, or who joins or declares his or her support for another political party or for an independent candidate, when the party has sponsored a candidate in a general by-election, automatically forfeits his or her membership of the party. That's why I asked a specific question about the status of these persons. If you say that they are still MPP MPs, that violates this provision of your constitution. Let the party take the necessary steps. There has to be an expulsion. These are conditions. Let the party take the necessary step. And you see, you are talking to someone who is a member of the party. And I've already told you that the one vote we needed. So why do you think we would take steps that will not deprive us of that? But it is for us to actually talk to them and say, this is what, we need you back and all that. We haven't done so. So why do you want to go? But based on their step, they have automatically expelled themselves.
No, yes, but you are saying you've expelled yourself, right?
No, I'm not the one saying it's the constitution of your party.
But look at 97. 97 said the person shall leave. 97 of the constitution. Has anyone done that?
No, 97.
So it is murky. It is murky where you are going with the situation where you will not allow the Supreme Court to make pronouncement on this. Both parties will urge their party, including the party constitution and every other thing, on the court. Until that happens, from today is the second. Is it the third? Second. By the way, congratulations to, why are you wearing green? Anyway,
okay.
Congratulations to all Prempeh College students today as our 75th anniversary.
Professor Gyampo, let me bring you in on this point, matter, please. Yes.
You're wearing green.
Prof.
Thank you very much.
And from the governor's perspective, no, gentlemen, don't distract me. No. We'll do that at the end of the show. Thank you. Prof. Gyampo. Yes. Don't be tempted to go into this.
No, I won't go into that. He can't distract me. You see, there should be an elite consensus of, on what we believe to be right and what is wrong in our democratic practice, and then also in the way and manner we think our courts and judges should conduct themselves. I think that what is right, what is wrong shouldn't be contingent on one's personal idiosyncrasies, one's perceived partisan leanings, and then one's belief in different schools of thought, so that Martin will say, if it were me, I would have done it like this. And Bobby will say, well, they could have also done. Can't we have an elite consensus on what we all agree that this is right, so that we go by it? So if we sit here, you see, we are all young. My father told me before he died that young people, we should be challenging the status quo, just to bring about development, and not always saying, oh, he said it, he was not wrong, and but he could have also said it like this, and that wouldn't have also been wrong. And then, so depending on where you stand, things go either way. I believe that don't you are not that young. Okay,
that's fine.
You want to die young?
No. For example,
all right. No. You are going. You've been raising metal. See your chest. You say you are not.
Thank you. For example,
so on this particular matter, I thought that it could have been handled in a manner that would quickly address the constitutional crisis in which I see we plaguing ourselves with. And then the Speaker's application for the stay of execution of the Supreme Court order are completely...
It wasn't the Speaker who filed the application.
I think you like it.
No. The Speaker's application set aside. Yeah, that's what I'm talking about. How it was completely thrown out. I thought that Speaker Bagman, when he started practicing as a lawyer, I'm sure many of the people on the bench were not even lawyers. Okay, and so I found it difficult to understand how a judgment could be ruled, could be given in a manner that suggests that he was so wrong, and his lawyer, that eminent Tadiosori, also was so wrong, and nothing was right about the motion that they filed in court. I thought that couldn't we have handled this in a manner that would have seen some gain, something good, some semblance of about but all of them unanimously saying that Bagban's case has no merit. I said, Bagban, so he doesn't know any law like that?
No, that's not what it means.
Well,
that's not what it means.
You said what?
Okay. That's not what it means.
How it works.
You see,
you are saying everything said doesn't amount to master, but there's a guy who should have been recused. Straight. That one is no brainer. The optics look bad. An MPP member sitting on an MPP case.
No. Let Professor Gyampo.
You see,
let Professor gentlemen, hold on.
I have wanted
to bring all lawyers here. They want to gang up against but they can't.
Let Professor Gyampo conclude on the point. Let him conclude on the point.
Exactly.
Hold on. Thank you, Gyampo, please.
So for me, the throwing out of Speaker Bagban's case, I was disappointed. I was surprised. I felt that it can never be true that there was absolutely no little merit in whatever he sought to present before the court. And I think that this was done in a manner that, in my view, disrespected the authority of Parliament, and it festers that, in my view, that bogus attempt to make Parliament subservient to the judicial arm of government. I don't think that would work at all, because, see, long before lawyers came into existence, and long before constitutions and laws were made, political thinkers, political philosophers, political theorists, and political scientists existed.
Long before what?
Long before laws were formulated. In fact, law before laws were formulated and constitutions were formulated and lawyers were... Oh, so let me make my point. Yeah, when we were beating about the bush, I kept quiet.
So, I was beating about the bush.
Okay. Oh, really? So long before lawyers came into existence, long before constitutions were formulated, political thinkers, political philosophers, political theorists, and political scientists existed. And it was their postulations and formulations that gave birth to the promulgations of constitution. That's how come John Locke is referred to as the father of constitutionalism. Okay, he was the first person to talk about the need for constitutions to check the rule of the sovereign and blah 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 blah.
He was a political thinker.
So he was a political thinker. So they were already in existence, and many of them had propounded theories that have existed and theories that have given birth to the functioning of the modern day political institutions that we operate. So you can talk about Baron de Montesquieu talking about separation of powers, A.V. Dicey talking about checks and balances, rule of law, etc., etc. Now, in the postulations of these political thinkers, okay, they look at the hierarchy of authority and power. They look at the structures of power and the organs of government, and they argue that these organs of government are independent of each other. So they are supposed to be separated from each other, and they are also supposed to be independent of each other, even though they also make room for checks and balances. But they never argue that the existence of checks and balances is supposed to be exercised in a manner that makes each or any of the organ of government subservient to the other. Okay, so they go on. If you look at all their readings, you do readings and look at what they stand for and all that. They try, okay, even though these organs of government are supposed to be equal to each other, they try to see who is who. And I have been disappointed that some people have spoken more about constitutional supremacy and are thinking that if you are talking about sovereignty and supremacy, it should always, within the state, it should always be with constitutions and not with people. Okay, but who designed constitutions?
We the people.
Okay, it is human beings who prepare the constitution. And so you can never talk about constitutional supremacy. If you are talking about supremacy and sovereignty, it resides more with the people. The people draft constitutions. And among the organs of government, where are the people who drafted the constitution? Where are they located? Where are they adequately and properly represented? It is on the floor of parliament.
Indeed.
I've always, last 2 weeks, I made the point, I'm making the point again, that you need 50% plus 1 to become the executive president of the land. Not all Ghanaians elected are president. Okay? Now, in other jurisdictions, to make justices of the courts accountable to the people, they are elected. But if you come to our part of the world, judges are appointed, and you are trying to say that, but if they are appointed, they are approved by parliament. You see, Martin said he is a realist. I'm a super realist. You should be questioning yourself. Why oftentimes members of parliament say, look, this man, we are not going to approve. This one, we are not going to let the person go through. And then all of a sudden, the person goes through. There was this case of one MP, one ministerial nominee, that all the minority side were at him that, look, this particular nominee were never going to, and they came out publicly. We are never, Ken Oforiatta, for instance, didn't you hear? We are not going to approve him. But that nominee that they spoke louder against her nomination was the one who even had more of the support in terms of votes
from the minority.
Yeah, from all of them. But I'm saying that as a realist, you should go behind the scenes to question what really happened. Isn't it the expression of the political kinkonism structure or stature of the president that tries to go behind the scenes to manipulate people and arrangements just to be able to ensure that the president's choice is always sailing through. So my point, but you are asking what I'm saying.
On both of them.
You are asking what I'm saying. Don't you know?
No, let's lay the blame on both of them.
So Manasseh's book, Joe Wise admitted that they are about to do certain business. They bring money from the presidency,
and no one challenged, controverted the issue. So let him proceed. Let me finish my point.
let him conclude.
What is your problem?
My problem is,
all right. So in trying to, please. No. Can I finish? Listen, can I finish? Let me finish.
Make your point.
I will have my say.
Let me finish.
I will also have my say.
So the point is this. The point is this. So in trying to locate sovereignty and who is who, okay, it is settled. And I said that, you see, many of the lawyers that I've seen, you just went to school to do law. You would have been better served if you had done, I went to school Form 1 to Form 5 and 6th form. If you had done O-level government, if you had done A-level government, when you went to SHS, if you had done some government before going to do law. I mean, this one is so elementary that the literature is settled on supremacy of parliament. And why do they say supremacy of parliament without even going to the literature? Common sense. Where are the people located? It is within the floor of parliament that all Ghanaians, whether you live in the sea, whether you live on land, whether you are in the jungle, you are all represented on the floor of parliament. Okay, you are all represented on the floor of parliament. And to the extent that sovereignty belongs to the people, it is where the people operate and function that you can say that you can locate sovereignty and you can say that they are supreme. And so by this analysis, I would find it difficult. Okay, I'm not saying that parliament should lord it over the other arms of government, but you see, in the idea of constitutionalism, parliament exists as a countervailing authority to the powers of the executive, so that power must always be in existence to counter the exercise of power. Lord Acton say, power power corrupts, absolute power corrupts absolutely. And so you always need parliament to assert its authority to be able to hold in check the functioning of the executive arm of government. In much the same way, parliament must exercise, its functions and powers in a manner that, like I argued earlier, not to be seen so much as, look, you are controlling or you are commanding or dictating, to other arms of government, but they must peacefully, coexist in harmony, such that even though I locate, or the literature locates sovereignty at the doorstep of parliament, it will not be so overbearing and be trying to overshadowing the other arms of government. And so when parliament, in spite of its powers and its supremacy, is being asked to be circumspect and measured in the way it conducts its activities, you would not expect another arm of government that, like the judiciary, to want to make parliament that is sovereign and supreme subservient to it. I was completely surprised that why are we going this route? That so we want to be in Ghana here, where parliamentary proceedings will be going on. Somebody may say, look, I disagree with what is going on in parliament. It takes the matter to court to injunct the parliament, wait until court settles the matter. That cannot happen within an era of the kind of relationship that is expected to be existing between the arms of government. What I know is a principle of judicial review. When parliament makes law that are unconstitutional, the judges are given the power under the concept of judicial review to take a second look at those laws and to say whether they are constitutional or unconstitutional, and that is it. You don't stop parliament, you don't grind parliament to a halt because you disagree with them. And you see, when we allow this to fester and to go on, we are headed for a deepened constitutional crisis, because I know if parliament truly wants to assert its independence, and its parliament is headed by the kind of speaker we have today, you can be sure that the speaker would ensure that parliament asserts itself also as a power block and also as a sovereign body where that provides an avenue for the representation of the people who are the owners of power that these power brokers, exercise. And so you can be sure that if parliament is going to say that, look, we are not going to pay heed to this, we are not going to respect this, And if they are also going to say that we are citing even some members of the court for contempt for impeding the flow of their work, where are we going to head to? So my point is that we know that Parliament all over the world is a master of its own processes. Everybody knows my position on the ruling of Speaker Okwe, and everybody knows my position on the ruling of Speaker Bagben. For me, I said they were both wrong, and I've adduced a lot of reasoning to back that. So that is not my focus now. But I'm saying that in going to in taking the matter to court, I think whoever did that was wrong. We could have allowed Parliament to sit. We could have allowed leadership of Parliament to dialogue, because Parliament is a master of its own processes. Let them sit, dialogue. The Speaker is a human being. I'm told the day that they adjourned Sinadine, he met with the Afinomakins and his group. He met with them, and I'm sure that when they met, they didn't go and fight. They dialogued, and so the Speaker is a human being.
No, they dialogued before the agenda.
Yes. So, but my point is that when they went there, they didn't go and fight, and so the Speaker is a human being. Majority leadership, minority leadership, you bring all of them together. Let us sit down and talk about what we think will be in the interest of Ghana. Like I said earlier, we should have an elite consensus of what we believe would be good for Ghana, and let us all pursue, rather than doing partisan politics and this intransigence. And look at, I saw the way a manner the Chief Justice was sounding in his utterances, not conciliatory at all, very adversarial, and I was wondering what will be going on in the minds of Speaker Bagben. If he gets his day, he would also want to speak his mind. And at the end of the day, where will we be heading to? And so this is where I argue that this matter cannot be settled by the Supreme Court. If we want peace, if we want to move on as a nation, if we want to ensure that there is no chaos in the lead up to elections, I am happy that I've been told that Council of State have met with Speaker Bagben. And I want to hope and believe that Council of State would also try and meet with the Supreme Court or the Chief Justices. Around this time, it is not only about law. My lawyer was telling me, Gary, he said the law is made up of 70% common sense. Okay, so in my view, given what is going on, whatever the way and manner the Supreme Court is going about things, the Speaker of Parliament would by all means also show the Supreme Court that they are also a power block, and indeed they are they house the people of Ghana. Yes. They provide the avenue where the people of Ghana are properly housed and represented. And so they would also flex muscles. And if you are going to allow muscles to be flexed, and you will not allow others to come in to intervene, to help, then it is going to be difficult, for us. So I'm calling on Council of Elders, a Council of State, to double up their actions and to make sure that they bring both sides together with the purpose of the view to bring in effective resolution, win-win resolution to this matter. I was working at the IEA during the 2008 elections, and I know that power was never going to be handed over after the 2008 elections. But we know the role that some eminent Ghanaians played behind the scenes. The role that certain eminent Ghanaians played behind the scenes. They didn't sleep. At night, they were calling people, talking to them and all that. I expect all these eminent Ghanaians to rise up and speak, to rise up and intervene with the view to ensuring that there is a certain resolution of this impasse. If you leave it to the Supreme Court alone, I tell you that we cannot have a resolution, because Parliament would always assert its authority, also to prove a point that they are also a force to reckon with, in terms of the power structure, within the state.
Professor Ransford Gyampo, in fact, someone just said to me that law in its purest sense indeed undiluted and also very clear, not contaminated. It is nice. But the moment you introduce politics, just a bit of politics into law, you would have created the most potent witchcraft ever created in humanity. We'll be back shortly after this quick break. Dr. Atta Kennedy is joining us right after this quick break. Dr. Atta Kennedy is joining us. In fact, he's on right now. So we'll go for this quick break. When we're back, he would have his take on this matter. Stay with us.
That issues and the SAR people, the SAR case.
Was it the CJ in 2020?
No. But in this particular instance, to the extent that they knew that people of SAR had been denied representation,
yes.
To the extent that the Just Chikwesin incident happened and they said he shouldn't go and represent his. I was expecting that. I was expecting that. You see, these things would have tempered the utterances and the brazen show of his commitment to fight the potential non-representation of people for just 2 months. I was surprised, and you should understand that. You should understand. Were you not shocked? See, the same. We should use the same principles to judge. To judge situations. So that my worry is that, you see, there are perceptions about the courts that are not too good. And if you look at, as he said, various Afrobarometer studies, the perceptions keep going down. And I'm thinking that the judiciary itself should be concerned and should be mindful about what it can do to redeem those sinking image. Okay. But if you do some of these, at one point in time you espouse a certain principles, and at other point in time it's like you don't really.
Point well made. Thank you. Point well made. You make your point. Yes. As a leading member of UTAG,
we don't have a lot of time, but unfortunately the earlier issues have taken the discussions. First of all, because he's a colleague, I didn't know he was coming here, right? Because he's a colleague, I would be charitable. But see, I don't see the basis for describing any grouping as silent majority. When you issued a statement signed by 57 people. Out of the 57 people, 36 were not UTAG members. Out of the remaining that were supposed to be UTAG members, 18 of them issued disclaimers. That you just constituted a WhatsApp group and then asked that they write their names and they are not privy to your intentions, and so they are checking out. And then you compare this, so do the algebra and mathematics. You compare this number to close to 3,000 people that voted. And then you compare you describe yourself as silent majority. I want Ghanaians to just look at this. But the point is this, there's nothing like UTAG went on strike following procedural improprieties. I think that if my colleague here really is following what happens in UTAG, and he knows our constitution, time will not permit me, because just 3 minutes. We should go about reading our constitutions and then go back to look at the reason why or how we even took the decision to go on strike. So close to 3,000 people across the 15 public universities voted. And why did we decide to go on strike? Maybe he doesn't know, but let me educate him that, look, in March this year, we decided that we would never be heard only when it comes to matters of our conditions of service. We would take on other national issues to ensure that UTAG also play its role as a countervailing authority, within the body politic. So in March, we brought about this issue of illegal mining, galamsey, irresponsible mining, and how these are leaving dangerous ecological footprints on our environment, how they are causing kidney failures and all that. So, unknown to him, UTAG had met several times. We had issued press statements. We had attempted to meet with government authorities. You call ministers, you call officials, and they don't mind you. Right. Based on that, we issued several statements. That's way back in March. So, in the process of issuing these statements, are we not getting hurt? Around that same, later on in the year, I think government attempted this sale of SNIT hotels. And you saw how we all came together to say, government, hands off that. And then so government backed off. Then we, UTAG, listen, we went to organized labor. Not organized labor taking a decision. We went to organized labor, told them that, look, if we have this power to push government away from selling this, then let us marshal that same power to force government, not to make government unpopular, not to make government unpopular and then do the burden of any political party, but let us put pressure on government just to ensure that government will do the needful to salvage, the challenge in which we find ourselves. We went to organize labor, and they bought into the idea. Right. Now, having bought into the idea, in the course of our deliberations and discussions with them, something happened, which I've already explained, and because of lack of time,
yes,
I cannot go there. So something happened, they said they won't do it again. And we said, okay, they jam a coin, I was won't go be more. And then she said, okay, we came to court your support, and you said you wouldn't do it again. I said, okay, if that is the case, then we're going to do it ourselves.
Thank you.
And our members all across the country had voted, to support that we should go on that industrial action. And so for anybody, any 57 minus 36 minus 18 group describing themselves as silent majority in comparing with over 3,000 people that voted, I mean, that's not with the greatest of respect to my colleague. That's not. I don't want to say it doesn't make sense, but it doesn't add up.
Okay, so yes, it is the unified front that you are looking for.
Let's see how we can work around. But your attitude was very, very well.
We were there. You put us.
We are most grateful for staying tuned. PENDREAM TV really appreciate your time. Please do subscribe if you have not yet subscribed as a new member. Turn the notification on so that you'll be notified on anything that will be posted onto the channel. Thank you.
PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.